Charles Katz was a quiet, well-dressed man in Los Angeles who made a living placing bets on college basketball games. He was smart, cautious, and he didn't do anything illegal in public. But every day, Katz would walk several blocks to a public payphone outside a bank on Sunset Boulevard. He'd step inside, shut the folding glass door, drop coins in, and make a series of phone calls. The FBI had been tracking him, convinced he was transmitting wagering information across state lines, a federal offense under something called the Wire Act. But here's the twist. The FBI didn't bug his home. They didn't tap his phone lines through the phone company. They put a listening device on the outside of the phone booth. They recorded his conversation without a warrant. Katz was arrested and convicted, and his lawyers appealed. The government argued it wasn't a private space. The phone booth is public. We didn't trespass. We just recorded what he was saying. But Katz's lawyer fired back with the argument that would redefine privacy in America. They said he shut the door. He expected privacy, and the Fourth Amendment protects people, not places. The Fourth Amendment protects against unreasonable searches and seizures, and says warrants must be issued based on probable cause. Back then, the definition of search was tied to physical intrusion. If the government didn't physically enter your property, many believed it wasn't a search. Katz's team challenged that idea. They said this was surveillance without a warrant, and that's a search no matter where it happens. The Supreme Court ruled in favor of Katz, a 7-1 decision. Justice Potter Stewart wrote the majority opinion, famously declaring the Fourth Amendment protects people, not places. Justice John Harlan agreed and introduced the now famous two-part test. Did the person have a reasonable expectation of privacy? And number 2, is that expectation one society is prepared to recognize as reasonable? Katz did have a reasonable expectation of privacy in a phone booth, and the government's recording without a warrant, that was unconstitutional. Katz versus the United States became the foundation for how courts interpret privacy in the digital age. Every time your location data, web history, or phone records come under legal scrutiny, Katz's influence is in the room. It expanded the Fourth Amendment from protecting only physical spaces to protecting the privacy people can reasonably expect, wherever they are. And here's something important about Harlan's second question. What society is prepared to recognize as reasonable is not frozen in time. Public expectations can shape constitutional protections. That means your voice, your outrage, your advocacy matters. So make noise. Anytime you see a constitutional right get violated, make noise. They are literally live streaming constitutional violations and using your tax dollars to carry out government overreach. Make noise. If they can erode any part of the Constitution while you sit on social media feeling outraged, they're eroding the whole thing. Here's something you can do. Call your reps. It doesn't take much to get their attention. There's an app called 5 Calls. It makes it very easy. And something else you can do is you can join an ACLU petition. They're making a real difference that you can be a part of.